Yep.
And for the rest of my life, I don't want to be with anyone but you. What are you doing?
Until death do you part.
I do. Well, maybe I wouldn't have to worry about other guys looking at you if you didn't dress like a whore. I just don't know what I would do if you were with anyone but me. Where you been? Hey, you look at me when I'm talking to you. Do you hear me? Look, I didn't want to do that. But you just don't listen. Who's that?
Hey! You sure you're okay? I'm fine.
Who's gonna take you in but me? You will never see your son again. How about next time I make sure you never leave the house again? Guess it's my lucky damn day. Look what I found under the bathroom sink.
Johnny, wait, just, no, hold on!
YWCA hotline. How can I help you?
Good day everyone, this is Group 6 and for today's video we will be talking about Republic Act number 9262. Now what is RA 9262? RA 9262 is the Anti-Violence Against Women and Their Children Act of 2004. It seeks to address the prevalence of violence against women and their children, abuses on women and their children by their intimate partners like husband or ex-husband, live-in partner or ex-live-in partner, boyfriend, girlfriend, or ex-boyfriend, ex-girlfriend, dating partner or ex-dating partner. What is the purpose of anti-VAWC? Number 1, to uphold the dignity of women and children and guarantees full respect for human rights. Second, to protect the family and its member, particularly women and children, from violence and threats to their personal safety and security. Who are the persons protected by this law? The following are the persons who are protected by RA 9262. Number 1, wife or former wife of the offender. Second, a woman with whom the offender. Third, has or had sexual relations with. Fourth, a woman with whom the offender has a common child. And last, the legitimate or illegitimate child of women within or without the family abode. What are the forms of violence which are covered under RA 9262? Section 3 of the said law covers several forms of violence, which are physical violence, acts that include bodily or physical harm, causing, threatening, or attempting to cause physical harm to the woman or her child, placing the woman or her child in fear of imminent physical harm. Second form of violence is sexual violence. These acts which are sexual in nature, committed against a woman or her child. Third, psychological violence refers to acts or omissions causing or likely to cause mental or emotional suffering of the victim, such as marital infidelity, repeated verbal abuse, public humiliation, threatening the woman that she will lose her child, stalking or following the woman in her workplace, school, or any public or private place without justification. And last form of violence is economic abuse. It refers to an act which makes or attempt to make the woman financially dependent on the offender, such as not allowing the wife to engage in a legitimate work, or solely controlling conjugal funds or properties, or taking the income of the woman. Battered woman syndrome. Section 3 of Republic Act 9262 defines battered woman syndrome as a scientifically defined pattern of psychological and behavioral symptoms found in women living in battering relationships as a result of cumulative abuse. It covers all forms of abuse, physical, emotional, psychological, verbal, for as long as these result to a pattern of psychological and behavioral symptoms. What are the penalties for committing VAWC? Section 6 of the said law provides the following penalties: the crimes of violence against women and their children under Section 5. For physical violence, parricide, the penalty is life imprisonment. Murder, the penalty is 17 years, 4 months, and 1 day to life imprisonment. Homicide, 17 years, 4 months, and 1 day to life imprisonment. What is the fine imposed on the offender of VAWC? In addition to imprisonment, the perpetrator shall pay a fine in the amount of not less than 100,000 pesos, but not more than 300,000 pesos, and undergo mandatory psychological counseling or psychiatric treatment, and shall report compliance to the court. Where can a VAWC be filed? Cases may be filed in the regional trial court, designated as family court of the place where the crime was committed. These courts have original and exclusive jurisdiction over these cases. Now, let's move to protection order. A protection order is an order issued under RA 9262 for the purpose of preventing further act of violence against a woman or a child specified in Section 5 of the law and granting necessary relief. The effects of protection order: first, to prevent the offender to do physical harm against the victim. Second, prevent the offender to threaten to do physical harm against the victim. And last, prevent the offender from communicating with the victim.
Who may file petition for protection orders? A petition for protection order may be filed by any of the following: the offended party, parents or guardians of the offended party, ascendants, descendants, or collateral relatives within the fourth civil degree of consanguinity or affinity, officers or social workers of the DSWD or social workers of local government units or LGUs, police officers, preferably those in charge of women and children's desks, punong barangay or punong kagawad, lawyer, counselor, therapist, or healthcare provider of the petitioner, and at least 2 concerned responsible citizens of the city or municipality where the violence against women and their children occurred and who has personal knowledge of the offense committed. So where to apply for a protection order? Applications for BPOs shall follow the rules on venue under Section 409 of the Local Government Code of 1991 and its implementing rules and regulations. An application for a TPO or PPO may be filed in the Regional Trial Court, Metropolitan Trial Court, Municipal Trial Court, Municipal Circuit Trial Court with territorial jurisdiction over the place of the residence of the petitioner, provided, however, that if a family court exists in the place of residence of the petitioner, the application shall be filed with that court. So how to apply for a protection order? The application for a protection order must be in writing, signed, and verified under oath by the applicant. It may be filed as an independent action or as incidental relief in any civil or criminal case. The subject matter or issues thereof partakes of a violence as described in this act. A standard protection order application form, written in English with translation to the major local languages, shall be made available to facilitate applications for protection order and shall contain, among other, the following information: names and addresses of petitioner and respondent, description of relationships between petitioner and respondent, a statement of the circumstances of the abuse, description of the reliefs requested by petitioner as specified in Section 8 therein, request for counsel and for reasons for such, request for waiver of application fees until hearing, and an attestation that there is no pending application for a protection order in any court. If the applicant is not the victim, the application must be accompanied by an affidavit of the applicant attesting to the circumstances of the abuse suffered by the victim and the circumstances of consent given by the victim for the filing of the application. When disclosure of the address of the victim will pose danger to her life, it shall be so stated in the application. In such a case, the applicant shall attest that the victim is residing in the municipality or city over which court has territorial jurisdiction and shall provide a mailing address for purpose of service processing. An application for protection order filed with a court shall be considered an application for both a TPO and PPO. Barangay officials and court personnel shall assist applicants in the preparation of application. Law enforcement agents shall also extend assistance in the application for protection orders in cases brought to their attention. So, for the enforceability of protection orders, all TPOs and PPOs issued under this Act shall be enforceable anywhere in the Philippines, and a violation thereof shall be punishable with a fine ranging from 5,000 pesos to 50,000 pesos and or imprisonment of 6 months. So for Section 13, which talks about the legal representation of petitioners for protection order, so if the woman or her child requests in the applications for a protection order for the appointment of counsel because of lack of economic means to hire a counsel de parte, the court shall immediately direct the public attorney's office to represent the petitioner in the hearing on the application. If the PAO determines that the applicant can afford to hire the services of a counsel de parte, it shall facilitate the legal representation of the petitioner by a counsel de parte. The lack of access to family or conjugal resources by applicant, such as when the same are controlled by the perpetrator, shall qualify the petitioner to legal representation by the PAO. However, a private counsel offering free legal service is not barred from representing the petitioner. Now let's talk about barangay protection orders or BPOs, who may issue and how. So barangay protection orders or BPOs refer to the protection order issued by the punong barangay, ordering the perpetrator to desist from committing acts under Section 5A and B of this Act. A punong barangay who receives applications for a BPO shall issue the protection order to the applicant on the date of filing after ex parte determination of the basis of the application. If the punong barangay is unavailable to act on the application for a BPO, the application shall be acted upon any available barangay kagawad. If the BPO is issued by a barangay kagawad, the order must be accompanied by an attestation by the barangay kagawad that the punong barangay was unable at the time for the issuance of the BPO. So BPO shall be effective for 15 days, and immediately after the issuance of an ex parte BPO, the punong barangay and barangay kagawad shall personally serve a copy of the same on the respondent or direct any barangay official to effect his personal service. The parties may be accompanied by a non-lawyer advocate in any proceeding before the punong barangay. Now let's talk about temporary protection orders. TPOs refer to the protection orders issued by the court on the date of filing of the application after ex parte determination that such order should be issued. A court may grant in a TPO any, some, or all of the reliefs mentioned in this Act and shall be effective for 30 days. The court shall schedule a hearing on the issuance of a PPO prior to or on the date of the expiration of the TPO. The court shall order the immediate personal service of the TPO on the respondent by the court sheriff, who may obtain the assistance of a law enforcement agents for the service. The TPO shall include notice of the date of the hearing on the merits of the issuance of the PPO. Now let's talk about permanent protection orders. PPO refers to protection order by the court after notice and hearing. Respondent's non-appearance despite proper notice or his lack of a lawyer or the non-availability of his lawyer shall not be a ground for rescheduling or postponing the hearing on the merits of the issuance of a PPO. If the respondent appears without counsel on the date of the hearing on the PPO, the court shall appoint a lawyer for the respondent and immediately proceed with the hearing. In case the respondent fails to appear despite proper notice, the court shall allow ex parte presentation of the evidence by the applicant and render judgment on the basis of the evidence presented. The court shall allow the introduction of any history of abusive conduct of a respondent even if the same was not directed against the applicant or the person for whom the applicant is named.
Good day, everyone. So to continue, The anti-VAWC law mandates that as a notice of sanction under Section 17, the words violation of this order is punishable by law should be printed in capital letters on protection orders. Under Section 18, in relation to Section 16, law enforcers are required to act on applications for protection orders within the reglementary period. Otherwise, they should be held administratively liable. Section 19 refers to legal separation cases where violence is alleged. Article 58 of the Family Code shall not apply. Here, application for protection orders must be carried out under this law. Under Section 20, the law mandates that applications for protection orders shall be given priority by barangay officials and the courts over all other proceedings. In Section 21, the law states that in case there is a violation of protection orders, a complaint shall be filed directly before any MTC, METC, or MCTC within the territorial jurisdiction of the barangay that issued the protection order, and may be appealed accordingly under the rules of court. For such violation, the offense shall be punishable by imprisonment of 30 days without prejudice to any other criminal or civil action that the offended party may file for any of the acts committed. In Section 22, the law states that protection orders shall be applicable and impliedly instituted with the criminal actions involving violence against women and their children. Under Section 23, the court may order any person against whom a protection order is issued to give a bond to keep the peace, to present two sufficient sureties who shall undertake that such person will not commit the violence ought to be prevented. And in Section 24, acts which are mentioned under Sections 5A to 5F shall prescribe in 20 years, and acts mentioned in Sections 5G to 5I shall prescribe in 10 years.
Section 25, public crime and violence against women and their children shall be considered a public offense which may be prosecuted upon the filing of the complaint by any citizen having personal knowledge of the circumstances involving the commission of the crime. Section 26, battered woman syndrome as a defense. Victim survivors who are found by the courts to be suffering from battered woman syndrome do not incur any criminal and civil liability, notwithstanding the absence of any of the elements of justifying circumstances of self-defense under the revised penal code. In the determination of the state of mind of the woman who was suffering from battered woman syndrome at the time of the commission of the offense, the court shall be assisted by expert psychiatrists and psychologists. Section 27, prohibited defense. Being under the influence of alcohol, any illicit drug, or any other mind-altering substance shall not be a defense under this Act. Section 28, custody of children. The woman victim of violence shall be entitled to the custody and support of her children. Children below 7 years old, older, but with mental or physical disabilities shall automatically be given to the mother with right to support unless the court finds compelling reasons to order otherwise. A victim who is suffering from battered woman syndrome shall not be disqualified from having custody of her children. In no case shall custody of minor children be given to the perpetrator of a woman who is suffering from battered woman syndrome. Section 29, duties of the prosecutors or court personnel. Prosecutors and court personnel shall observe the following duties and dealing with victims under this Act. First, communicate with the victim in language understood by the woman or her child and inform the victim of her case of rights, including legal remedies available and the procedure and privileges of indigent litigants. Section 30, duties of barangay officials and law enforcers. Barangay officials and law enforcers shall have the following duties. First, respond immediately to a call for help or request for assistance or protection of the victim by entering the necessary whether or not a protection order has been issued and ensure the safety of the victims. Confiscate any deadly weapon in the possession of the perpetrator or within plain view. Transport or escort the victims to a safe place of their choice or to a clinic or hospital. Assist the victim in removing personal belongings from the house. Assist the barangay officials and other government officers and employees who respond to call for help. Ensure the enforcement of the protection order issued by the punong barangay or the courts. Arrest the suspected perpetrator without warrant when any of the acts of violence defined by this Act is occurring or when he or she had personal knowledge that any act or abuse has been committed and there is imminent danger to the life or limb of the victim as defined in this act. And lastly, immediately report the call for assistance or assessment of the DCWD Social Welfare Development or LGU's accredited non-government organization. Any barangay official or law enforcers who fail to report the incident shall be liable for a fine not exceeding 10,000 pesos or whenever applicable criminal, civil, or administrative liability. Section 31, healthcare provider response to abuse. Any healthcare provided including but not limited to an attending physician, nurse, clinician, barangay health worker, therapist, or counselor who suspects abuse or has been informed by the victim of violence shall A. Properly document any of the victim's physical, emotional, or psychological inquiries. Properly record any of victim's suspicions, observations, and circumstances of the examination. C. Automatically provide the victim free of charge a medical certificate concerning the examination or visit. Safeguard the records and make them available for the victim upon request of actual cost. Lastly, provide the victim immediate and adequate notice of rights and remedies provided under this Act and services available to them. Section 32, duties of other government agencies and LGUs. Other government agencies and LGUs shall establish programs such as, but not limited to, education or information campaign and seminars or symposia on the nature, causes, incidents, and other consequences of such violence, particularly towards educating the public on its social impacts.
Good day, everyone. So we go now to Section 33 of RA 9262. In Section 33, a punong barangay or barangay kagawad are prohibited from ordering, forcing, or unduly influencing the victim to compromise or abandon any relief sought under this Act. In Section 34, any person, private individual, or public official are exempt from any liability if they respond or intervenes to ensure the safety of the victim. Such person should act in accordance with the law and should not use any violence or restraint greater than necessary. In Section 35, provides additional rights of the victims, which are to be treated with respect and dignity, to avail of legal assistance from the PAW of the DOJ, to be entitled to support services from the DSWD and LGUs, to be entitled to all legal remedies and support as provided for under the Family Code, and to be informed of their rights and services available to them, including their rights to apply for a protection order. So for the next provisions, it provides for entitlement of the victim for damages, a hold departure order which should be expedited by the court, and if the victim is indigent or due to immediate necessity, docket fees and other expenses are waived. Section 39, the different agencies which composes the Interagency Council on VAWC, and these are the DSWD, the National Commission on the Role of Filipino Women, Civil Service Commission, CHR, Council for the Welfare of Children, DOJ, DILG, PNP, DOH, DepEd, DOLE, and NBI. Section 40 provides that the SWD and LGU shall provide mandatory program and services for victims such as temporary shelter, counseling, psychosocial services, rehabilitation programs, and livelihood assistance.
Section 41, Counseling and Treatment of Offenders. The DSWD shall provide a rehabilitative counseling and treatment to perpetrators towards learning constructive ways of coping with anger and emotional outbursts and reforming their ways. When necessary, the offender shall be ordered by the court to submit to psychiatric treatment or confinement. Section 42, Training of persons involved in responding to violence against women and their children cases. So all agencies involved in responding to violence against women and their children cases shall be required to undergo education and training in order for them to be acquainted with the nature, extent, causes of violence against these women and children, legal rights and remedies of these victims, the services and facilities available to these victims, the legal duties imposed on police officers to make arrests and to offer protection and assistance, and techniques for handling these incidents of violence and to minimize the likelihood of injury to the officers and promote the safety of the victim or survivor. Section 43, entitled to leave. Victims are entitled to paid leave of absence up to 10 days in addition to the other paid leaves provided by law. Any employer shall prejudice the right of the person under this section shall be penalized. An employer who shall prejudice any person for assisting a co-employee who is a victim under this act shall likewise be liable for discrimination. Section 44, Confidentiality. All records pertaining to cases of violence against women and their children, including those in the barangay, shall be confidential. So public officials and employees shall respect the right to privacy of the victim. Whoever publishes or causes to be published any format, name, address, or any detail of the victim without the latter's consent shall be liable to the power of contempt of the court. So any person who violates this provision shall suffer the penalty of 1 year of imprisonment and a fine of not more than 500,000 pesos. Section 45, funding. The amount necessary to implement the provisions of this act shall be included in the Annual General Appropriations Act. The gender and development budget of the mandated agencies and LGUs shall be used to implement services for the victim of VAWC. Section 46, IRR. Within 6 months from the approval of this act, the DOJ and other government agencies and 3 representatives from non-governmental agencies to be identified by the NCRFW shall promulgate the implementing rules and regulations of this act. So here are the provisions on supplementary application, separability clause, repealing clause, and effectivity clause, which provides that this act shall take effect 15 days from the date of its completion, complete publication in at least 2 newspapers of general circulation.
In the case of Kane versus Roggenkamp, GR number 214326, dated July 6, 2020. Alastair John Kane was charged with RA 9262 but was subsequently acquitted. Patricia Roggenkamp filed a separate civil action for damages. The issue here is whether or not Patricia may file a separate civil action considering Kane was acquitted on reasonable doubt. The Supreme Court held that the criminal action filed against petitioner was one for physical injuries in the sense contemplated in Article 33 of the Civil Code, that is, bodily injury. The civil action under Article 33 may be pursued before the filing of criminal case, during the pendency of the criminal case, or even after the criminal case is resolved. The only limitation is that an offended party cannot recover twice for the same act or omission of the defendant.
Now let's talk about the case of Pension Gratuity Management Center versus AAA 2018. In this case, the Supreme Court ruled that PGMC may be directed to withhold half of its members' pension for direct remittance to any legal spouse in an action for a permanent protection order under the anti-VAWC law. So for the quick facts of the case, a wife filed an action for support against her husband, who was a retired military person. And then the trial court issued on February 12, 2010, ordering the issuance of a permanent protection order. In this order, the PGMC is requested to hold half of its members' pension to be directly remitted to the wife. Part of the order was also giving the support in arrears in the amount of 130,000 pesos, which represents the monthly support of 5,000 pesos commencing from January 2008. So the issue of the case is whether or not PGMC may be validly ordered by the court to withhold half of its members' pension for direct remittance to any legal spouse. So the Supreme Court ruled in the affirmative and cited in the case of Republic versus Yahoo and stated that the court held that PGMC may be ordered to automatically deduct a portion for the retirement benefits of its member recipients for direct remittance to the legal spouse as by way of support in compliance with a protection order issued by the trial court pursuant to the provisions of Republic Act 9262 or the Anti-Violence Against Women and Their Children Act of 2004. The court declared therein that RA 9262, which is a special law, a later enactment, a support enforcement legislation, and one that addresses one form of violence, which is economic abuse against women and children, should be construed as laying down an exemption to the general rule that retirement benefits are exempt from execution. The court therein noted that RA 9262 itself explicitly authorizes the courts to order the withholding of a percentage of the income or salary of the defendant or respondent by the employer, which shall be remitted directly to the plaintiff or complainant, other laws to the contrary notwithstanding. So the petition was denied.
In the case of Pavlo versus Mendanilia, GR number 181489, April 19, 2017, penned by Justice Leonen, petitioner here is Stephen Pavlo, an American citizen, is the husband of Maria Sheila, while respondent is Cherry Mendanilia, mother of Maria Sheila. So what happened here is that early on to their marriage, Maria Sheila filed a complaint for slight physical injuries against her husband, but was dismissed. So the mother filed for a protection order under the anti-VAWC law. The issue here is whether or not Cherry Mendanilia had personality to file a petition for the issuance of a protection order under the anti-VAWC law for the benefit of her daughter, Maria Sheila. To that, the court upheld the doctrine that the mother of a victim of acts of VAWC is expressly given personality by Section 9B of the anti-VAWC law to file a civil action petitioning for the issuance of a protection order for her child. In filing such a petition, she avails of a remedy that is distinct from the criminal action under Section 5 of the same law.
In the case of the Socorro versus Van Welsem, the facts are as follows. That Van Welsem and Norma del Socorro met and fell in love with each other and eventually got married. After a year, they were blessed with a son, whom they named Rodrigo. Unfortunately, their marriage ended and was divorced. Petitioner then came back to the Philippines with their son, believing in the promise made by Van Welsem of the monthly support for their son. But he failed. Thus, he was sued for violation of RA 9262 for failing to give support for his son. But Van Welsem filed for motion contesting that the court has no jurisdiction over his person because he was an alien. RTC ruled in favor of Van Welsem. Petitioner filed a motion for reconsideration alleging that respondent was guilty for violating Article 195 of the Family Code for failing to give support, but it was denied. Thus, the petition raised the following issues. Whether or not a foreigner national has an obligation to support his minor child under Philippine law. Second, whether or not the foreign national can be held criminally liable under RA 9262 for his unjustified failure to give support his minor child. On the first issue, the court said yes, the obligation to give support to child is a matter that falls under family rights and duties. Since the respondent is a citizen of Holland or the Netherlands, we agree that the RTC Cebu that he is subject to the laws of his country, not to the Philippine law, as to whether he is obliged to give support to his child as well as the consequences of his failure to do so. On the second issue, the court said that it cannot be gainsaid, therefore, that the respondent is not obliged to support petitioner's son under Article 195 of the Family Code as a consequence of the divorce covenant obtained in Holland. This does not, however, mean that that respondent is not obliged to support petitioner's son altogether. In international law, the party who wants to have a foreign law applied to a dispute or case has the burden of proving the foreign law. In the present case, respondent hastily concludes that being a national of the Netherlands, he is governed by such laws on the matter of provision and capacity to support. While respondent pleaded the laws of the Netherlands in advancing his position that he is not obliged to support his son, he never proved the same. True, foreign law do not prove themselves in our jurisdiction, and our courts are not authorized to take judicial notice to them. Like any other fact, they must be alleged and proved. In view of respondent's failure to prove the national law of the Netherlands in his favor, the doctrine of processual presumption shall govern. Under this doctrine, if the foreign law involved is not properly pleaded and proved, our courts will presume that the foreign law is the same as our local or domestic or internal law. Thus, since the law of the Netherlands as regards to the obligation to support has not been properly pleaded and proved in the instant case, it is presumed to be the same with Philippine law, which enforces the obligation of parents to support their children and penalizing the compliance therewith.
So in the case of Republic versus Yahon, Daisy Yahon is married to Sergeant Charles Yahon. She was physically abused by her husband, so RTC issued a temporary protection order or TPO against Sergeant Yahon, and included in TPO is for him to provide financial support to Daisy. Daisy said that Sergeant Yahon never complied with the TPO as he continued making threats and inflicting physical abuse on her and failed to give her spousal support as ordered by the court. RTC granted Daisy's petition and issued a permanent protection order or PPO and directed Sergeant Yahon to give to Daisy 50% of whatever retirement benefits and other claims that may be due or released to him from the government, and said share shall be automatically deducted from his benefits and claim and be given directly to Daisy. So Republic here argues that it cannot comply with the RTC's directive for the automatic deduction of 50% from Sergeant Yahon's retirement benefits and pension and to be given directly to Daisy, as it contravenes an explicit mandate under the law governing the retirement and separation of military personnel. So the issue in this case is whether a military institution may be ordered to automatically deduct a percentage from the retirement benefits of its enlisted personnel and to give the same directly to latter's lawful wife as spousal support in compliance with a protection order issued by the RTC pursuant to RA 9262. So the court ruled here yes. Section 8G of RA 9262 used the general term employer, which includes in its coverage the military institution, and where the law does not distinguish, court should not distinguish. The Section 8G applies to all employers, whether private or government. The reliefs provided in Section 8G thus fulfills the objective of restoring the dignity of women who are victims of domestic violence and provide them continued protection against threats to their personal safety and security. The scope of reliefs in protection order is broadened to ensure that the victim is offended party is afforded all the remedies necessary to curtail access by a perpetrator to the victim. This serves to safeguard the victim from greater risk of violence, to accord the victim and any designated family or household member safety in the family residence, and to prevent the perpetrator from committing acts that jeopardize the employment and support of the victim.
In the case of Garcia versus Derlon, there are 4 issues relating to RA 9262. Whether or not the issue of constitutionality of the VAWC law was properly raised. Second, whether or not RA 9262 is violative of the Equal Protection Clause. Third, whether or not RA 9262 is a vague law. Finally, whether or not RA 9262 is violative of due process. On the first issue, the issue on constitutionality of the VAWC should have been raised at the family court level. The family court is a regional trial court which under the law is law with authority to decide on the constitutionality of laws. So second, the VAWC was based on a valid classification. The Supreme Court discussed the local and global literature which led to the creation of the VAWC. The unequal power relationship between women and men, the fact that women are more likely than men to be victims of violence. Third, the law does not intend to make every quarrel between spouses punishable under the law. It even enumerated or particularly defined the punishable acts. The enumerations of the law were even based on a UN declaration on the elimination of violence against women. Finally, a protection order is an order issued to prevent further acts of violence against women and their children, their family or household members, and to grant other necessary reliefs.